State, would you please set a record for Tiara Butler?
Yes, Your Honor, thank you. This is State of Indiana versus Tiara Butler, cause number 64D012306F65582. Defendant appears in court in person and with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
State, are you asking for a jury setting?
I am, Your Honor.
Okay. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes.
You do understand that?
Yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon, or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here. Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so
Yes.
we'll upload them into the file and strike them from the record, as I mentioned.
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing and reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Faretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay. I mean, I can do that Faretta hearing, but I'll let Mr. Pribble go for the day and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Faretta hearing with you because it takes a little bit of time.
It does. Okay.
And I'm
Is
going to ask Bill,
is it
can you
possible I can come back?
What'd you say, Judy? What'd you say, ma'am?
Myself. Okay.
So here's a form that I need you to review, and you can step back, and then I'll call you back up here at the end. We can go through the Faretta with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. So, I mean, like I'm saying, you can step back.
Okay.
We'll not conclude your matter today we'll let Mr. Pribble not have to be present for the Faretta hearing since it's just regarding whether she can appear pro se, and I can talk with her directly about that.
Okay.
So you can wait until the end of our call and then come back and we can handle this.
Okay, thank you.
All right. Is that all you had, Mr. Pribble?
Yeah, that's all, Your Honor.
Okay. Well, I'm glad that you did the heavy lifting. Tiara Butler, we'll go back on the record in 64D01-2306F65582. I have a request for pro se. She would like to represent herself in this matter. So I'd like to conduct a Faretta hearing. Yeah, I have one here, but I'll use this one. That's fine. Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Are you under the influence of any alcohol or drugs today?
No.
All right. Yeah, we set a trial already. Your trial set for August the 18th and 19th, and you've indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you a
you have a
whole new one.
spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Faretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court.
I comprehend that.
Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tiara Butler. You talk about final order to settle and close,
Yes.
different things like this.
Yes.
And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had in a high.
That's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
it should be April 16th or 15th.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Those are criminal matters, the violations that have been held against me. Yes, that's a lot of violations.
You understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
we-
pseudo-legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it, and I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a Brandy violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Faretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are,
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have an attorney.
I did that too. You know what he did?
I don't know, man.
Ignored me.
What you have filed through the clerk's office, you're saying are matters in equity. We don't recognize what you're talking about in
You
these
guys
filings.
This is a bank. This is a bank. I understand how the
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever.
Hold on, let me finish.
No. I'm not gonna let you finish that
Okay.
particular
I
statement.
said I want to
Because
preface
I
this.
just
Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes.
You
Yes.
will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a
Yes.
minute.
It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something that, and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So
telling
you will
us
not
to
strike
follow
it?
the rules.
You won't strike it down or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay,
You realize
But-
that?
but let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
What I also want to say something, and I also am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executor. As such, this office give notice of its authorizations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executor. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
No, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned. Okay, are you prepared for the suppression hearing?
I am, Your Honor, yes.
All right. How would you like to proceed?
Your Honor, it's defendant's motion, so
It is their motion, but often the state would go and present evidence related to the motion. Have you reviewed the motion to suppress?
have, Your Honor, yes, I'm ready to proceed. I'll call my first witness.
Do you believe it's the defense burden on this one?
I believe so, but
Let me look at it. Ms. Butler, what's your position on the motion to suppress? You feel like you need to present evidence, or should the state present evidence to show that the statement that they are relying upon is a viable one?
I would like to present the evidence.
You want to? You want to present evidence first?
I will follow whatever you just lead me, okay? So I don't want to jump ahead. So you tell me what you would like from me.
Yeah, state, I think you should go first on this. Yeah,
I'm ready to call my first witness, Your Honor.
sure. Want to have him come up?
And were you assigned to investigate a matter involving the defendant in this matter?
Yes, I was.
And do you see the defendant here in the courtroom today?
Yes, I do.
Can you please point out where she's sitting?
She's sitting at the table directly in front of me.
And who is the defendant?
Tiara Butler.
Can you please let the record reflect that the witness has identified the defendant?
So noted.
Can you walk the court through why you were investigating the defendant?
I was contacted and received information from one of our analysts from our headquarters regarding suspicious fraudulent transactions that were being conducted by Ms. Butler based on data that he was reviewing. In response to that, I installed cameras into the facility to record her during the transaction time. And during a period of, I believe it was May of 2022 through January of 2023, I located approximately 20 transactions that she had conducted with no customer present, which were for cash refunds and other things. And so the next part of my investigation was to conduct an interview of Ms. Butler.
And when you say that you place cameras in the facility, what facility are we talking about?
This is the Valparaiso downtown post office.
Is that located in Porter County?
Yes, it is. Ms. Butler was asked if she'd be willing to answer some questions, and she agreed. So then we set up an area inside the post office where we were going to conduct an interview of her.
And then did you conduct an interview with Ms. Butler?
Yes, I did.
And can you describe to the court what did you first do in the interview?
Well, first thing we did, like I said, we got the room set up. We had chairs and positions so that the three of us could sit down. The first thing I did is presented her with what we refer to as our Garrity form. And it's basically an acknowledgement of rights form that we present to employees that are not in custody. And I went through that form with Ms. Butler, presented it to her. She read through it. Once she completed and signed the form and we witnessed it, I confirmed with her verbally that it made sure she understood the rights that were explained that she had placed her initials next to when she was completing it, and she stated she did.
Okay. And did you also sign that form?
Yes, I did.
And then did Agent Klemick also sign that form?
Yes, he did.
Agent Sokol, I'm handing you what's marked as State's Exhibit 1. Do you recognize that?
I do.
And what is it?
This is the Garrity Acknowledgement of Rights form for employees not in custody that was presented and completed by Ms. Butler.
And is that a true and accurate copy of a waiver of rights form that Ms. Butler signed?
It is.
Okay. Your Honor, State would move to admit State's Exhibit 1.
Any objection, ma'am?
Yes, I do object.
What's the objection?
The object that it was given towards the end of my statement because I had to sign, because I had the pen at the time. Because at the beginning, I didn't have a pen. I had the pen at the time, and I did sign, but how you know that he signed it later is because look at the times at the end. It's at 10 o'clock. It's in his penmanship.
So your objection is related to authenticity or
It was
relation?
towards the end of the statement, when I was writing the statement. That's when
Okay.
I was given that form. I wasn't,
Evidentiary rule is your objection?
okay, I was just explaining that.
I'm asking you.
Yes.
What's your basis for your objection? What's the evidence?
My objection that he did not give it to me at the beginning. He gave it to me towards the end.
I think it goes to authenticity or something, but it's overruled. We'll admit it.
And there are 4 paragraphs, I would say, listed 1 through 4, correct?
Yes,
Okay. And beside each of those paragraphs, Ms. Butler did initial.
that is correct.
What does the first one say?
It says, I have the right to remain silent if my answers may tend to incriminate me.
And number 2?
Anything I say or do may be used as evidence against me in a court of law and in other proceedings, including administrative proceedings.
And number 3?
If I refuse to answer questions because my answers may tend to incriminate me, I will not be disciplined solely for remaining silent.
And number 4?
This interview is strictly voluntary, and I may leave or stop answering questions at any time.
And again, that is signed by yourself,
Yes,
and it is also signed by Ms. Butler,
yes,
and it is also signed by Agent Klemick.
yes.
And what was the defendant's demeanor like throughout the interview?
She was appeared to be nervous. Her mouth was dry at times when she was speaking with us. It was a challenge to try to keep her focused on what I was specifically asking, because she tended to segue off into other things. But she was responsive to the questions.
And after Ms. Butler signed her acknowledgement of rights form, what then happened?
I conducted the interview, asked her the questions that I wanted to ask regarding the transactions that were captured on video. She explained certain things that other employees were stealing from her drawer and her unit reserve. She explained that she was having severe financial hardships at the time when she was assigned to that office. Her car was repossessed. When she got it back, her interest rates were increased, her loan doubled. And she just kept explaining things like that.
And was Ms. Butler given the opportunity to write out a statement?
At the end of the interview, correct, we offered her the opportunity to write out a voluntary written statement. It wasn't mandatory, wasn't required. And she agreed and chose to write one.
And she wrote a statement?
She did.
And did she sign that statement?
She did.
And did you ever make any promises to Ms. Butler?
No, I did not.
Object.
What's your objection?
The reason I object is because he would not accept my
Oh,
statement.
whoa. Okay, so it doesn't sound to me like you're having an objection, Ms. Butler. What it sounds to me like is you're about to try to engage in cross-examination.
No.
Yes, ma'am. Make sure you understand the order of proceedings, okay? She's going to ask him questions. In the course of that time, you may have objections to certain evidence.
Yes.
Those evidentiary objections must be based upon evidentiary rules.
Okay.
What you attempted to do a few seconds ago is start to say your side of the story or to question or ask about certain facts that you disagree with. And that's my job, is to make a determination about whether or not the agent's telling the truth or not.
Okay.
And your job when you question him is to bring up the thing you just wanted to object about. in a question form to him. Do you understand?
Yes.
Okay, so you've just got to work with how we do our
Work with you.
process.
Yeah.
Okay? And this objection, I'm not sure what your grounds would have been, but I will overrule that objection and council may proceed for the state.
Agent Vasoko, there were no promises or inducements offered to Ms. Butler for writing out her statement.
No. The statement was completely voluntary. She didn't have to write it if she didn't want to.
And did Ms. Butler ever ask to leave the interview?
No, there was periods during the interview where she asked to get some documents that she was wanted to present to me, and she got up and she went and got the documents from the other room. She came back, she presented them to me, but other than that, she never requested to leave or end the interview.
Did Ms. Butler ever ask to rewrite her statement?
No.
Again, ma'am, I heard you say object, but it doesn't sound like it's an objection. It sounds like your proper cross-examination of this witness, okay? So hopefully you're noting down the things that we're talking about here so you can ask those questions of this witness.
So Agent Vasoko, again, Ms. Butler was free to leave this interview at any time.
Yes.
I have no further questions.
Good afternoon. Good evening. On February 1st, is it true when I asked you, who are you? And you stated that you was an interviewer and that you was only coming there just to interview all employees, just to see how things are. You don't have no control of firing or doing anything in that matter. Is that true or false?
The statement is not completely true. I advised you that I was with the Inspector General's office.
You did not.
Yes, I did, and I showed you my credentials.
No, you did not. That's a lie. That's not true.
Okay, ma'am, and what
But-
we're doing there, that is called argument,
No.
okay?
Okay.
So you want to take those notes down. At the end of this, there's going to be the opportunity for you to tell me the reason why you think I should rule in your favor. And one of those would be that you think he's given a dishonest response to your questions, okay? So that's the order of proceedings. I see you're getting emotional. If you need a moment, we can take a moment.
All right, the next question. When we sat down, Andrew was in the corner and you was on the side. And I decided actually, to write a statement. When I wrote the statement, did you read the statement?
When you completed the statement, I reviewed it, correct?
Okay. And did you, as you read the statement, did you state that you are not going to take this statement unless I took food and money for gas? Because if I don't, you're not going to accept it. Is that true or false?
That is not true.
Oh my God. Okay. If that's not true, let's keep going. All right. As we proceeded, did I ever ask for a copy? No, let's start this one. As I ever asked for another statement? Because when I read my statement, it was with errors. Did I not ask you for another one? True or false?
I do not recall you asking me for another statement form.
Okay. After that one, true or false? I'm trying to picture myself in that moment, exactly how it happened. When you asked about refunds, did I show you examination, I think it's called accountability examination report? And that I went into where the postmaster was, and I went into the cabinet. And I said, I want you to look at the examination report, see how it had changed, because there was a lot of discrepancies before I came down there. And then as you looked at their report, you said, where is Don? And I told you, this young lady is retired. Did you not say, did you want a copy of that? Yes or no?
I believe I told you that if you wanted to give me a copy, that I would take the copy from you. Yes.
Okay. All right. So Now, for that being said, also in the statement, when I wrote the statement, didn't I ask you, you asked me, this is how you did it. You asked me if you write this statement stating that you can explain your hardship and state that you took money for food and gas, that the prosecutor will be more leaner to you.
No, that is not correct. When I presented you with the statement form after you agreed to and said you wanted to complete one, I explained to you that it was a voluntary statement and it needed to be truthful and accurate.
So you trying to say we did not exchange the statement back and forth, true or false?
I don't understand what you're asking.
What I'm saying is, if I gave you the statement the first time to read, did you read it? Yes, true or false? The first time I gave it to you, do you read it?
I honestly don't recall if I read it prior to you completing it or if I read it after you signed the form, but I would have reviewed the form because in the form, anytime that you would have made a cross out or anything like that, we have to have you put your initials over that cross out, indicating that you did that. We also drew lines through any of the statement form.
When I had the statement, and remember I was talking about a whole lot of stuff when you was interviewing me, right?
Yes.
I was talking about my, the management. I talked about the postal inspectors. I talked about, people did not care about, then I told you about the EEO that I had filed.
Sure.
I also told you about customers, witnesses that is needed.
She's testifying, Your Honor. She can do that when she's
No,
on the
no,
stand.
no, this is part,
Yeah, I understand your objection.
But it was part of- it was part of-
Is there a question in there somewhere?
no, this was part of the interview when we was talking about it. That's how it ended up on that paper.
I understand, but is there a question you plan to ask?
Okay, well,
So I'll
what I was doing was,
sustain the objection.
okay,
Please ask your question.
my question is, was you aware of those things before you came downtown?
Was I aware of what things? What
Were you
telling me?
aware of my dealership situation? Was you aware of postal inspectors ever investigating the fraudulent activity that occurred at my job? Was you aware of that?
No, I was
Okay.
not aware of that. prior to
Okay,
that.
okay. Let me see. Was you aware that management has a responsibility of internal control by chance?
Internal control.
Internal and control, like meaning financial responsibilities. Are you aware of that?
I'm aware that postal management does
Yes.
do certain things to monitor and control
Okay.
internal things.
When you had made a statement before you came down to me, because you said you had showed her video, right? Showing whatever alleged had happened. Did you ever have you ever did any type of auditing with her? Anything like that in that matter?
Without specifics, I can't answer that question.
Okay, the reason why I ask is because management was totally aware of what I was doing. Totally aware. And the reason why I asked these questions because I was listening to you how you got introduced to this by a data analysis, correct? A data analysis had given you a spreadsheet of fraudulent or refund transactions, correct?
That is how this
Okay.
investigation was
That's
initiated.
how it started.
Correct.
So do you automatically just go directly to the employee, or do you go directly to management employee, or do you just do both?
I go to where the evidence leads me.
Okay, so, okay. Now, also, I want to make one more statement and then I'm done with you. Okay?
You're gonna make a statement or are you gonna ask?
Yeah, I got one more question. Yeah, one more question. If you was not aware of my financial situation, why is there evidence submitted to the court?
I don't understand what you're
Well, you
asking.
have it. This is the hardship that I was explaining to you, and I'm trying to figure out why the court has it, and it's irrelevant to, here goes for here. And it was an exhibit. Exhibit 6. The reason why I say this, because I have gotten your evidence that you had submitted. And I was like, why is this private administration is submitted? And it was addressed to Eric Holm, the governor at the time. And it was talking about the fraud that had occurred downtown and what had happened and stuff like that. And I'm trying to figure out, did you read this stuff before you came down? And that's why you wanted me to focus on financial hardship in the interview, because it started to line up.
Objection. Agent Visico already testified that he made no promises to her, or I'm sorry, that he did not ask Ms. Butler to put anything in her statement about financial hardship. She did that on her own.
Correct. Okay, so I'll sustain that. Are you gonna ask a question, ma'am?
The question is, why is this submitted? This private administration process is submitted as evidence.
You presented this to me during the interview. That's why I had it, and that's why I included it.
And now you can have a seat back so the microphone can pick up your statements.
I had no knowledge of that prior to you giving it to me during the interview, which I accepted because you insisted that I take the statement, that document. That's why it's included in my report.
I couldn't, okay. I couldn't have. I'm sorry, but I couldn't have because we was in the interview.
Yes, but you had access to documents that you said you wanted to give to me to present. That was one of the documents you presented to me. I had no knowledge of that prior to that interview with you.
This was not given to you. Only thing I gave you.
Ma'am, so this isn't a question.
Okay.
Sounds to me like that would be testimony you would give of your own if you have a story that contradicts what the agent's testifying about, okay? So do you have any further questions?
No, Your Honor.
Before you get started,
Okay.
I need to have your attention for this. Do you plan to testify today?
To explain everything, yes,
You plan to testify?
I can.
Okay, so I'm going to put you under oath
Okay.
when you testify. Do you understand that?
Yes.
And you know what the Fifth Amendment is?
I can waive my rights if I, not to self-criminate myself.
So you understand what the Fifth Amendment is, that you don't have to give any statement that would be incriminating?
Yeah.
Did you know that if you testify and I put you under oath and you testify, that the prosecutor is going to have the opportunity to cross-examine you?
This is not trial, is it?
Ma'am, this is a hearing
This is a hearing.
and there is evidence that is being presented at this hearing. And if you are under oath and you testify, the state's going to have the opportunity to cross-examine you.
Okay.
And if they ask you a question, you're going to have to answer it.
Okay.
You understand that?
Yes. Can I have?
And that you can't invoke your Fifth Amendment rights after you've already waived them.
Okay.
You understand that?
Yes.
So I'm going to have you answer whatever question they ask.
Okay, that's
You
fine.
realize that?
Yes.
You're willing to accept that risk.
Yes.
Okay, you understand that it's probably not in your best interest.
It's probably not in my best interest at this time, or
Do you understand that?
I do, not really completely, but before we move on to the prosecutor interviewing me, can we please interview Andrew first?
Ma'am, it is your case. If you want to put
Yes, can we bring Andrew up?
Andrew, I'm sorry,
you
it would
please
be more
put
formal if I
Andrew?
knew your last name. on the witness stand, then you could have him testify. Would you like to call him as a witness?
Yeah, well, I can call him as a witness, please.
Okay, then you're going to want to say, I call.
I call Andrew as a witness to the stand, please.
Okay.
Okay, Andrew, when you attend to the interview, was you sitting there witnessing both our actions, George actions and my action? Was you notating this? Yes
I
or
was
no?
present at the interview and I took notes, yes.
Okay, okay. Towards the end of the interview regarding to the statement, do you witness George reading the statement?
I don't recall
Okay.
if he did or not, but I'm sure that Special Agent Vasilko read the statement with you.
So okay, let me ask you this question. How far apart that you were standing by each other that you could not see him reading?
We would have been close. Are you talking during the interview?
Yes, because it was very small.
Yeah, we would have been next to each other.
Exactly. So you trying to say you did not see him pick up a piece of paper, that he did not read the statement? You didn't see him at all. So that's what you're saying?
Ma'am, I've interviewed with Special Agent Vasilko several times, and he is pretty thorough. And typically, he would review again when statements are completed that
Okay.
they would be reviewed.
Okay, so I'm asking, did you see him read it? That's all I'm asking.
Again, I don't recall for sure, but I'm sure he did.
Okay. Now, next question. Did you ever see George give me the statement back and told me to write again? I had to write the first time. Then I wrote again, which was the second paragraph.
I'm not sure what you're asking.
I'm gonna ask you again. Do you ever see me sitting down, writing down the statement? True or false?
I believe you completed the statement that day, yes.
Okay. Did you see me hand the statement after I got done?
Yes, it was given back to Special Agent Vasilko.
Okay. Did you see George hand me back the statement?
I think you gave it to Special Agent Vasilko. He would have reviewed it with you, and then obviously it was taken so he could put it in his case file, and it would have been presented to a prosecutor and then USPS management.
Did you did you see George stand there by the door, pacing, and stated that he would not accept my statement unless I write that I took food and gas? Did he ever make any type of statement like that?
I did not see that.
So you're trying to say that you didn't hear anything, you was sitting right next to him?
Ma'am, I believe that are you talking about the food and gas comment?
Yes, that food and gas comment. That's the only one I'm really trying to get you right there. Did you ever hear George make a statement that I need to admit that I took money for food and gas?
I did not.
No further question.
Is there any further evidence, Ms. Butler, you wanted to present?
Yes, I do. I was trying to look for, because I did not have it all together. It was a form that I presented that I gave to him during the interview. Give me just a second, okay, Judge? Did I hand this to you or to you?
So I'm not sure what it is, but before you do anything with it, I'm going to put you under oath. Okay, and I just want to admonish you again, I don't want to chill your right to be able to testify on your own behalf.
Okay,
Okay?
thank you.
Because I feel like that the motion to suppress rights under the Fourth Amendment, you're going to be able to talk about whatever you want to talk about.
Okay, thank you.
But you still have a Fifth Amendment issue that you need to be fully aware of.
Yes.
You say incriminating things.
Mhm.
The state's going to get a chance to cross-examine you. They're going to have to cross-examine you in what we call the scope of whatever you testify about during your direct. But anything you say can be used at trial for what we call impeachment. So if you change whatever testimony at trial that you might give today, they'll be able to use whatever you said today and say that you said something different today.
I get what
You understand all that?
I'm following you.
Okay, so I just want to make sure you're aware of what you're doing. Please raise your hand to be sworn. You just swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes.
Okay, so what's important for me about this document is that you first identify what it is. What's this document you have in your hand?
This document is it's the post office retail floor for the stamp stock.
Okay,
Okay,
and how did you come to possess it?
I had one of the employees give it to me.
Okay, and do you believe that it's a true and accurate copy of whatever the employee gave to you?
Yes.
Okay, is that
Okay.
employee still employed with the Postal Service?
They might have, but I don't know. They're not there no more.
Do you know their name?
Yes, I do.
Well, you'll have to share it with us.
Mr. Stanley.
Mr. Stanley provided that to you. And was Mr. Stanley providing that to you in the course of his own occupation at the Postal Service?
Yes.
Okay. Why don't you show it to counsel so she can have a look at what you've got there? We'll have it preliminarily marked as Defendant's Exhibit Number 1. Is this your only copy of the exhibit?
I only brought one for myself. I mean,
If you give it to me, I'm taking the copy.
that's
I'm
fine.
not giving it back.
It's fine.
I'll make sure you're clear.
Or can I just bring you a legible copy? Because I can bring,
No, this is going to have to be the one.
because it's on the front and the back. Let me see if I have another copy.
And Ms. Butler, I'm going to have you bring that up to me. I'll make a photocopy of it so that we don't take your last copy. All right.
Exhibit number
Now,
one.
would you like for me to admit defendant's number 1?
Admit defendant number 1.
Okay, so you would say, Your Honor, I would move to admit defendant's exhibit 1.
Your Honor, I would like to admit exhibit number 1.
State.
I'm going to be objecting. First of all, to relevance, first of all, I don't know what Ms. Butler is trying to get out of this exhibit. It's not relevant to her own motion today, Your Honor, the proceedings today. It has nothing to do with suppressing her
Yes, it does.
confession. And I would object to it's not authenticated correctly. If she got this from Mr. Stanley, he's not here to testify to the authenticity of this document. I don't even know what this document is. I believe it's some stamped stock sheet, but again, she's not going to be able to properly admit it without it being authenticated by whoever gave it to her, whoever wrote it.
Okay,
Can I object?
so I need your response on relevance.
Okay. First off, my name is on here.
No. Relevance. How is it relevant?
Is it relevant to this case? Is
No.
because
How is it relevant to your motion to suppress?
how is it relevant? So this is the statement that was given to the OIG. Because I mentioned something about he wanted a copy, and I said something about Don. This is what I given him because I wanted him to invest further.
Okay, but how is it relevant to the question that we have here, which is that the handwritten statement you provided was given by inducement, coercion, or improper promise? What does this document have to do with that?
Well, this document is basically, I know about the suppression about the statement, but I also put in there what was handed to him about that. what was given to him, because I remember I had asked for a copy of my statement so I can clear up some errors,
Okay,
but he refused to give me a new form.
okay.
And then I end up also stating that I went
So you
in.
think it's relevant to
Yes, it is.
impeachment of their testimony?
Yes, it is, because they,
It's fine. I
Okay.
understand your position. Now, the state brings up that it's not properly authenticated. I ask you a few questions, preliminary ones, about how you got the document.
I got it through the post office, county, what do you call it? The files that I copied for him. It's the same files that he got copies of.
Okay,
And he went in and got another copy of the same document.
okay.
And it was given to him.
And so here I agree with the state that you haven't properly authenticated the document. But in addition, it is hearsay. And it is hearsay that doesn't fall within any of our hearsay objections.
Okay, you say it.
Exceptions, rather, exceptions. Because of that, I have to not admit it. But regardless, because you've offered it, we still need to take the document from you. So please rise up and bring it back up to me. I need you to bring it back up here. That's fine, but we need to take them one at a time. So I'm going to take this. Defendant's 1 is not admitted. I sustain the objection to admissibility. What else, ma'am?
I have a daily closeout certification checklist.
Okay,
This is needed that he or management that's supposed to do on a daily checkout regarding to money orders, stamps, refunds. This is necessary because this is what he had asked me in the interview.
okay, hold on for a sec, though. Let's try to get the document admitted. So you remember the process here? You're going to want to stand up, take it over to the court reporter. She's going to put Defendant's 2 on it. We're going to be able to use that number for identification purposes. You're going to want to show it to the prosecutor. And then tell me more about it. How did you come into possession of this document?
I already had this document already
Okay, how did you get it?
working there.
Did you run this report?
Yes, I had to run multiple reports.
Is this a report that you specifically ran?
No, it's just my daily checkout reports. Like, just say, for example, when I go downtown and go to the main, I would exchange reports because they'll run out and I'll just give them a copy of it because we have to wrap them up sometimes.
Okay, so let me ask you again.
Okay.
How did you come into possession of this report?
By working at the post office.
And while you're working at the post office, are you in files? Are you at a computer attached to a
Yes.
printer?
Yes.
How
Files.
was the document generated?
It's just copy. It was already generated. It's just a repeated copy.
Okay, now let me ask again then. How was it generated?
Copied.
It was not copied. It had to have been printed first.
Yes, it had to been printed. Well, I was just telling you how I received it.
And on what system was it generated?
What system it was generated? I think management will use what you call it, Word, and they will actually generate all the information that we need to do on a daily basis.
Did you input all the data in to create that form?
No, I did not.
Did you sit at the computer and press print for that form?
No, it was already pre-printed.
Did you take the document that you found already printed and photocopied on a photocopy machine?
Yes, yes,
All right. And you're moving for the admissibility of Defendant's Exhibit Number 2.
yes.
State.
I'm going to object to same issues. Relevance, Your Honor. It's not going to be properly authenticated and hearsay.
Ma'am,
No.
what do you have on relevance? How is this important to your question about whether your statement was coerced?
Well, according to my statement being coerced, he asked me about the ledger that's listed. And he asked me,
Okay.
it's in there. It's in there. He
So
asked
again,
me,
you're using it for impeachment purposes.
yes, yes.
Okay.
He asked me,
Do you want to
which-
try to add anything about authenticity?
Hmm?
Do you want to try to add anything about authenticity of the document?
I mean, that's as best as you can get it. I mean,
Did you at any point look at the computer screen of whatever generated this document and compare the two to make sure whatever was on the printer screen, the computer screen, was the same thing that was generated by the printer.
We didn't never use the computer, Your Honor. Only
You
thing,
never saw the computer original of this.
no,
before it was printed.
we never used one from computer. It will always been passed through each other.
Okay.
Like we'll bring it downtown or the main, we'll make a few copies or send it in the up.
Okay. Do you have any response on hearsay? Do you
So-
falls in under any of our hearsay exceptions?
No, it's not hearsay. It's required because it shows this is financial documents that I am presented to you, Your Honor, because you cannot present something. Go ahead.
Ma'am, the question is to admissibility, okay? It might not be hearsay because I'm not really sure what it is altogether, but I think it is hearsay because it's somebody else's statement. I'm not sure what it's meant to do here because I'm not sure it's relevant. But in any case, Exhibit 2 is not admitted. It's not relevant. It's not authenticated.
It's very
I don't believe it
relevant.
to be hearsay.
It is
So
relevant.
please bring that up as well.
This sounds like an unfair trial, Your Honor.
It's not unfair, ma'am. There are rules of evidence. When you did your Faretta hearing, you and I went through and talked about how you're going to have to be responsible for presenting evidence and you're going to have to be responsible for knowing the rules of evidence and knowing the rules of procedure and how everything works. You told me you would do that. Okay. And I told you that if you do a bad job or if you're not able to get your documents authenticated, we talked about it specifically, or admitted into evidence that that was going to be on you and that you couldn't come back later and say, well, Judge, I was a bad lawyer, or tell the higher court, well, Judge, I was a bad lawyer in my own trial. I did a terrible job and I've been convicted of this. You can't come back and do that. So you have
Okay.
to be able to present your case like a lawyer because you've asked to represent yourself. And
I did, and I did.
I understand.
Yes, I did. And I,
Present the rest of your evidence.
I
We have
agree.
55 minutes left and we still have to get to your motions in limine.
so every time I present something, you saying it's not authenticated. I thought we was just talking about the motions like you said.
Everything that you try to admit into evidence here has to pass stringent rules of evidence before it can be admitted into this proceeding. It's not relaxed rules of evidence. This ain't small claims court, right? There are no relaxed rules of evidence. There are big kid court rules of evidence here.
So can I go get it authenticated and resubmit it?
No, ma'am. Today is your hearing. You've known about this hearing for, I don't know, a week
Just
or
last
so.
week? And the only thing you had mentioned
But
to
you
me.
would have had to have gotten the documents authenticated in advance, and I can't teach you how to practice law. You chose to represent yourself, and now here you are at your hearing, probably incapable of getting in the documents that you want to get in, even if they are relevant. And it's not my problem. It's a you problem.
Yes, I understand
Okay.
that.
And no, you can't go get them and come back because this is the hearing. You go to trial in like 2 weeks or so.
So authenticate them. Oh my God. I think I might have some that I actually filed.
I can't teach you how to practice.
No.
But do you have any idea what you would have to do to authenticate any
Hold on.
either one of these?
I think I did it already. It was way back last year. I did authenticate them.
I don't think you have, ma'am.
I had actually got it.
I don't think you can authenticate them yourself, if that helps.
The documents came from the post office. No, I cannot authenticate them, but they are very relevant to this case and to this matter to order to prove theft.
Okay, ma'am.
They are very relevant.
But what about your motion to suppress, where you say that was
My-
coerced from you?
My motion to suppress is very truthful and
That
honest.
sounds like you're arguing.
No,
You're under
no,
oath.
no,
You're supposed
no.
to be testifying now.
Yeah,
Are you going to testify now?
I'm not testifying, but I'm explaining, then I will testify.
Well, if you're going to explain, that's argument.
Oh,
Wait
okay.
till after your testimony to give me whatever argument you're going to give.
Okay.
Do you have any other evidence you want to present?
If it's not authenticated by me,
You could authenticate documents you produced yourself.
only thing I really did is my motions that I did.
Which wouldn't be evidence, ma'am. It's already part of our record.
I got a question for you, Your Honor.
Probably not going to answer it. It's not question and answer time for the court.
Okay.
Time for you to be testifying or presenting evidence related to your motion to suppress. We are down to 52 minutes.
I'm gonna hurry it up. Can I testify then?
Go ahead. What do you want to tell me?
I want to tell you about my job.
Please keep it relevant to your motion to suppress.
Okay. I've been working for the post office for 17 years. And I always try to follow the rules and procedures. I was not really trained thoroughly on my position. Management have an internal responsibility for stamp stock, refunds, money orders, and everything that contain financially. When I discovered that management was not doing their job, I reported it to the EO. And they refused to train me when I got into that position. Also, I want to let you know that according to refunds, I actually requested through management to use the refunds because they would never offset the debt, or they would never look into it when I keep reporting it, that is keep messing my stock up, because we have a.
Ma'am, I need to redirect you here, okay?
I need to say this though. I got
I
to
don't
get
think
it
you
out.
need to say it because it's not relevant to what you've said.
It is. It's in my statement.
Consider in your.
It's
motion
in
to
my
suppress.
statement, Your Honor.
Please don't talk over me because my court reporter can't type what both of us at the same time. Your motion to suppress says that at your interview, that they coerced a statement.
They
from you,
did. Mhm.
Okay, and the evidence that you've just talked about in your testimony has nothing at all to do with that.
Well, let's
So-
talk about my evidence then.
Talk about the
The
interview.
The interview.
Talk about what they did to coerce you at that interview.
Okay, so at the,
Contradict.
okay.
Stop talking when I'm talking.
Okay,
And contradict whatever evidence you wanted to contradict while they were testifying.
okay. Let me close my eyes. At the interview, I asked my postmaster who was these two young gentlemen to come in. She said she didn't know. As I sat down, they had, Andrew was on the right of me, sitting on a garbage can, and George was on the right by the door. He was standing there. He mentioned that about you do not have to answer questions. He did mention, he just stated that you can plead the fifth. At that point, I'm like, pleading the fifth for what? And as we proceeded, he started asking me questions to how long I've been working for my job and stuff like that. And I told him how long. And then I ended up start talking about the EFT. The EFT regarding to the money orders that we got scammed. I was talking to him more about that regarding to management did not intervene, and they end up making me pay for something that was irrelevant towards me because I wasn't not responsible, because management did not step in to verify or also to make sure I was doing things correctly. And the only reason why I did the money orders is because postmaster knew the customer. The customer wanted to set up a trust, and she came in and got money orders through me. So he didn't want to talk about that. He wanted to talk about the refunds. So I was like, okay, let's talk about the refunds. He asked me, did I know anything about the PBI, the meter? I think it was about the express. And I said, yes. And then he also told me to explain. And then he also asked me about the P.O. Box customer, about P.O. Box 509, which was Charles Mars. And he asked me about a money order. When he asked me about a money order, and it was $160, and I said, yes, I know about that money order. I said the customer had given it to me towards the end of the transaction, because the customer, John Mars, was an elder. And I've been knowing him for over 10 years. And he was in a retirement home at the time. So he would have a neighbor, different random people would come up there and assist him and bring stuff and make sure his mail or whatever. When it was time for them to close out the transaction, the young lady brought me a key. And then my job is normally take the keys back, and I end up getting her what do you call it? A refund. Okay, I gave her that. And when I gave her that, she was filling it out, and I put the keys away. And then as I was coming back, she said, "Oh, never mind. You can have the refund." I didn't even know how much it was at the time. You know, I get money from customers all the time for being a good customer service. So I ain't think nothing about it. But when he interviewed me and told me about that, and I told him, "Oh, I know the customer, don't worry about it," and stuff like that. I said, "Don't even use that." So then he asked me about other stuff regarding to I have experiencing hardship. That's the reason why you're doing the refunds. And I was like, "Yes, I am. I have experienced, receiving hardship." I said, "A customer came down here and ran my credit and tried to sell me a car. And there was some fraudulent activities, and I had reported to the postal inspectors. And they did not do anything about it." And so that's how that got introduced into the statement. And so after that, I told him about the training. I said, "They didn't really want to train me down here. They just don't care. Every time something happened, they don't do nothing about it." So he said, "Write a statement." So I'm like, okay. So that's when I started writing my statement. That's why I said my job has been sabotaged, and that management, I started naming all the management, postmaster, postal inspectors, and then I start talking about the dealership, the fraudulent activities and everything that was going on, that nobody didn't care. And then I also mentioned something about I was using my own money to offset the debt because I got tired of doing it, because I have some evidence to show you what happens, because when you don't offset we have like a stamp threshold that's $100. As long as you stay under $100, it does not create a 571, which is a discrepancy report.
Ms. Butler,
No,
you just
that's
stop.
part of it.
I need to stop you, okay?
Okay.
Because we got to drill down on this. I've got motions to suppress, and we got to do the pretrial. We have 45 minutes left. What I need, can you tell me in your own words, how did they induce you to make your statement?
It was towards the end when he read it and he didn't want to take it.
So tell me exactly what happened.
I just written up my statement, and I looked at it and I read it, and I said, "Dane, I need another form." And that's when he was like, "No, you just initial," like he did say. He said, "Just initial the remarks." And then when he read it, he was like, "I'm not taking this." And I was like, "Why not?" He said, "Because you need to say that you took money and gas. Took money for food and gas." And I was like, "But I did not do that." And he said, "Well, I'm not taking your statement then." And I was like, I said, "Okay, under one condition." This is what I did. I said, "Under one condition." I said, if I write this, would I get a copy of it?" And he said, "Yes, you will get a copy." So what I did was I wrote the statement. He said, "Make sure you explain about your hardship." Okay. And I was like, okay. And then when I wrote it down, because that's the second paragraph towards the end, I reserved my rights. I reserved my rights without prejudice, because I wanted to challenge it. And the reason why I wanted to challenge it, because I wanted to file a union, because my union store wasn't there. So that's the reason how it was written the way it was.
Do you think there was any improper promise?
Improper prompt? That was the improper prompt. He refused to take my statement as it is, because if you look at it from the beginning to the end, it's run-on sentence. Like you said, like he was telling you in the interview, I was talking about everything.
Okay.
And then it ended up conflict, and on the paper, I was talking about everything.
Is there anything you want to add? I'm just trying to keep you on task because
Okay.
we're running out of time, like I said.
I'm gonna end it.
And you got into a lot of things, but only needed to hear those specific parts about what you think happened that was either inducement, coercion, or improper process.
That was that was it right
That
there.
was what was important to me.
Yes.
Are you not going to put that statement in? Is that a strategic reason?
No, Your Honor. I mean, I would like to put it in, but I mean, given,
You don't want to put it in?
no, I do.
Okay, so let's get it in through Ms. Butler. Go ahead before I.
Can I say something about
You-
before I really object? Because if you read that statement, I mean, just read the context. Because apparently you're not reading it. If you just read it, it talks about more like a whistleblower, like somebody's trying to express something that's going on in the job.
Ms. Butler, you said certain things about when certain things were written in the statement. That's what I really want to take a look at.
Yes, I need you.
Okay.
Can you read it out loud, please?
No, ma'am, I'm not going to read anything out loud. It's not story time for me. It's not story time for you. But I'm going to go ahead and let the prosecutor cross-examine you at this time.
Okay.
State.
Ms. Butler, so it was explained to you at the beginning of the interview that you did not have to answer the special agent's questions. Is that correct?
No, that's not correct because
You just testified to, though, that you were told that you did not have to answer their questions. That's what.
no,
No.
he just stated that I can plead the fifth. That's what he stated. I can plead the fifth. But in my mind at the time, I stated that why would I plead to fifth? Because I don't like what you're talking about. Because like I just said, I didn't know who they were.
But you still continue to talk to the special agents. Is that correct? They interviewed you.
Yeah, they interviewed. Like I said, I didn't know who they were.
Can you take the mic closer to you?
Yes.
Go ahead.
And you were presented with, you were able to write a statement, correct?
Yes, I was able to write a statement. Yes, I was.
Okay, and you wrote that statement, correct?
Yes, I did write the statement. Yes.
Your Honor, if I may approach the,
Yeah, please.
all right, Ms. Butler, I'm showing you what's been marked as State's Exhibit 2. Do you recognize that?
Yes, I do recognize it.
Okay, and what is that?
This is the statement that I have written on February 1st.
And is that a true and accurate copy of the statement that you wrote on February 1st?
Is it a true and accurate copy? This is a copy. This is not a true copy, but this is a copy. This is not an original statement,
No,
but
that's why I say this is a true and accurate copy of your statement.
but it's a copy of the statement. It's not the original. Where's my original statement? But yeah, it's the statement.
Your Honor, State would move to amend State's Exhibit 2.
Any objection, ma'am?
I object because due to the fact that it doesn't flow. And also it doesn't state who, it doesn't say where, it doesn't say from. It doesn't even line up with his statement because
Ms. Butler,
no,
I'm looking at the statement as it relates only to the motion to suppress.
yes. And the reason why I'm suppressing because it's not a voluntary statement. When you voluntary a statement, it needs to be clear. It needs to be voluntary that just like I gave you my emotion.
Ma'am,
It has to be clear. This is not a clear statement, Your Honor.
ma'am, that's not a proper objection. Do you have any grounds to object?
But my grounds to object that this is not a clear context statement. It doesn't state. It's not a clear statement, Your
All
Honor.
right, it's overruled. States 2 is admitted.
Judge.
I'm happy to have a look at it. In fact, I think I have to for this hearing. Further questions?
Yes, I guess regarding the statement, Ms. Butler. So again, this is your statement that you wrote, correct? And you initialed, at least like you initialed on each page of that statement, correct? Your
Yes, I initial with the little errors that I was trying to correct at the time.
And you also signed that statement, correct?
Yes, and I reserve my rights. Can you look at that?
Yeah, that's on the page. number.
Yes, it said without prejudice, didn't it? Doesn't it say without prejudice?
It does.
So that statement was written that way because I wanted to challenge it under circumstances I was under. Because there was nobody else but those two men and myself. And look, if you just read it,
Yeah, I have no further questions.
Okay. Yeah, ma'am, did you want to add anything then in sort of a redirect of yourself? Did you want to try to say anything else?
I mean, like I said, I reserved my rights and I basically did that so I can later challenge it and let them know what the misconduct that occurred that led me to write the last paragraph. And also, it doesn't state that I took money from the post office. It doesn't say anything about the refunds. It doesn't state any type of criminal contempt for sin. No, because it's not a clear statement. I'm trying to figure out how can you submit it just because it got exhibit on it that it doesn't correspond with the probable cause. It doesn't. I mean, you got to put evidence that lines up so it can sound truthful. It doesn't make any sense.
This may be great for the trial, but we're here on a motion to suppress today.
I know, and it
I'm
needs to
only
be
trying to look.
suppressed.
I'm
Because-
only trying to look at whether there is evidence related to the motion to suppress, okay?
Yeah, and that's it.
Anything else you want to add? Any other testimony you want to provide? Any other evidence you want to provide? Documentary evidence at this time?
Well, I would like to submit evidence that there's no proof of theft.
All right, that's not evidence, ma'am. That's argument.
It is.
Ma'am, it's argument. Most assuredly, it would be argument.
I'm-
That's not even relevant. So on the motion to suppress, state argument.
Thank you, Judge. Just briefly. So, Your Honor, we heard from Agent Klimek and, excuse me. Thank you, Vassilko today, Your Honor. They both testified that Ms. Butler, they interviewed Ms. Butler at the downtown Valparaiso post office, that when they first started the interview, she was given her waiver of rights form, which she stated she understood. She even testified today that she was told that she could leave at any time. She signed that form. She initialed. She said that she understood it. She still went forward with the interview. She was able to leave at any time. There was no doors closed. There was no hindrance for her to move about, to actually leave that interview, Your Honor. She wrote her statement, which is State's Exhibit 2. She wrote that out free and voluntarily. We heard testimony from Agent Vassilko that at no point did Ms. Butler ask to rewrite that statement. Ms. Butler signed that statement, dated it. We heard testimony that she was not coerced in any way. She wasn't made any promises regarding her putting certain things in that statement. Your Honor, given that, and this was a non-custodial interview, she was told that at the very beginning. Given that, Your Honor, her statement in the interview should not be suppressed.
I object, and let me tell you why I object.
Wait a minute, ma'am. Wait a minute, ma'am.
Okay.
State, thank you.
Yes.
I just need now for you to argue. Sure, it's an objection, but it's just your contrary argument. Go ahead.
The
Argue
reason why I
in support of your motion to suppress.
the reason why I object, you can't just up and leave out of an interview. We are taught to cooperate. And whenever an officer is presented, you must cooperate. And we're not taught to leave from any type of interview. We have to comply. If I wanted to leave, I would have left, but I couldn't leave. I was in a situation on the clock and I was instructed by a postmaster. It's not like I did it at home. I was instructed by the postmaster to speak with them. And by me be given instruction, I cannot just say, no, I'm not talking to them. So when I went back there and spoke with them, I cooperated with them and not knowing who they were, because by not being a small office, different random people come there all the time to talk to me about retail products and all kind of improvement. So I'm thinking they're one of them. I didn't know who they were. And still they start asking questions and we've been scammed. So I'm thinking they come to talking about the scam that we've been scammed on. So of course I'm going to comply and talk about the scam, what had happened at the post office. I have record of that too.
Anything else you want to add, ma'am, on the motion to suppress?
I just want to know through my suppression,
You want to,
That-
what?
in my suppression, that the OIG now follow procedures, protocol procedures. I just want to know that they follow procedures.
Okay. All right.
That's all I want to know.
All right, Ms. Butler. Did you get the copies of the state's witness and exhibit list for trial?
And
I've been in the envelope that my staff just gave you.
Oh, one more thing.
Oh.
One more thing, Your Honor.
Go ahead.
With my suppression, I did mention something about documents, financial documents. Because I'm trying to figure out where is the documents.
Ma'am, do you believe you have all your discovery in this case?
I think I did put that in there.
You received everything from the state?
I only receive certain things, but there's no financial documents in there.
Did you get your records from Mr. Pribble?
Yes, but no, he sent them to me email, but
Okay.
he did not hand give them to me.
Do you object to us having your email address so that the court clerk can email you orders and things from the court and make it part of the Odyssey system for serving you documents since you're pro se? Can we have your email address?
Yeah, you guys have my email address.
We don't have it. Can we have it?
Oh yeah, I can give it to you.
What is it?
T4@gmail.com.
We'll start with the witness list. You don't have a seat with that stuff. They filed this yesterday. The state of Indiana filed this yesterday. So you can see they've got their witness list there. And just because they've listed these witnesses doesn't mean that they will all be here or that they will all testify. You understand that? This is a list of witnesses, but it doesn't promise that they're going to offer testimony or that they'll even be here. I want you to realize that. Do you understand?
Yes.
Okay, and do you see the exhibits there? Spend some time with the exhibits. Looks like there are about 9 things. Well, there are 7 things and then some catch-all.
Okay, so this is mine, okay. Can I ask you a question about one of these exhibits?
I'm waiting.
Just one, not exhibit, witness. Where Dory, the
Go again?
postmaster, will she be able to attend?
I don't know.
Because that's the one that I need to really address some things with her because.
Last time we were here, I told you that if you wanted me to have people come, I needed you to get their addresses and things.
But the state has Dory on there. Dory is one of their witnesses. And
Irrespective of that, I just explained, just because she's on this list doesn't mean
doesn't make
she's
sure,
gonna show up.
this is very unfair, Your Honor.
What's
because
unfair about it, ma'am?
Where's unfair is that the young gentleman just was deceitful on the stand
Ma'am,
regarding
I
to
have
my.
accountability. I'm the one who decides whether or not somebody lied here today. You understand that? That's what I do.
I got you, but
That's what the
I've been-
jury's going to do during your.
Yeah, and it's just, this is my first time, so please have mercy on me. I'm learning, I'm observing, I am trying to get through this. I'm the one is a victim in this matter. I'm been going through all this. While they still have their jobs, I'm jobless.
Ms. Butler, all I'm trying to find out is
My statement needs to be suppressed because it does not clearly state who, where, when, and how, and also.
Ms. Butler, we've moved on from your statement and the motion to suppress. We're now talking about witnesses. You've suggested you want Dory Veligan here. I just told you if you want her here, you need to get her address to me. So I can get a subpoena.
I don't know, because I left that post op 3 years ago. I don't know where everybody stays.
I don't either. and I'm not going to do your super sleuth.
But that was part of, I thought the state would know where they live because they part of their witnesses.
Not their job. So
Well,
if you want to guarantee her appearance here as best you can, you need to get me her address, and I'm going to put a deadline for addresses. We're set on the 18th, right?
Yes, Your Honor.
So I think a week from today, July the 30th, if you're going to get if you want any subpoenas sent, you have until July the 30th to get that to me so I can get subpoenas down to the clerk and they can get them served. Even
So-
that, it's going to be tight.
so you trying to say that I don't have no evidence in the record? And that's what you're saying, that I can't submit no evidence because my stuff been submitted already in the record?
I never said anything like that. I don't know what you mean by it, but what I did say earlier today is that you're going to have to learn how to authenticate evidence and make it ready for submission in the trial. Nobody has any evidence into the trial yet, if that was what you were suggesting.
Okay,
The trial hasn't started yet, so there's
Okay.
no evidence into the trial yet.
okay. So can I ask you this question? Because I'm learning from you. The evidence that I have, can I still present them at trial?
I will allow you to attempt to present relevant evidence, but
Okay,
you're going to have to follow the rules of
I will
evidence for
follow.
admissibility.
okay. Thank you,
And
Judge.
you're going to have to authenticate documents, and they're going to have to be ones that are admissible. So if it's hearsay, meaning it's a third-party statement, then you got to figure out how to get that in. If you
Okay, if it's a hearsay, okay. I will try
It's my
to,
job to teach you how to do that. You
No,
have
I will
to
find, I will figure it out. Thank you.
figure it out. All right. So you believe you have the exhibits that are recited in the state's list of exhibits? There's no question in your mind that those 7 items are in your possession at this time? The acknowledgement of rights form, the spreadsheets, the written statement, your interview, photographs, videos, police reports.
Okay, hold on. It's the defendant knowledge of right form. Spreadsheet, summarized losses, fraudulent activity from 2022, defendant sworn statement, defendant interview, photos, video, police report, any exhibit listed by the defendant. This is what I had requested in a sense, but then it looked like,
Did you get the video evidence from
I never,
Mr. Fribble?
nothing. Nobody gave me nothing.
You don't have the video evidence from Mr.
Nothing.
Fribble?
They didn't give it to me.
I have that, Your Honor. it is quite lengthy. There's several videos, so I can, even today, I can have it put on a USB and have Ms. Butler pick it up from our office.
Yeah, Ms. Butler, you can either pick it up or they can send it to you, but I'm going to put a deadline on the state to get
Can I-
video evidence prepared before the end of
Can I
the day.
say something about the video? Can I say something about the video?
We just need to stop talking over each other, but yes.
Okay. The reason why I don't really care about the video, Your Honor, is because management gave me authority to do what I did.
Butler, regardless of whether you care about the video or not, insofar as the state has a duty to provide a complete set of evidence to you,
Mhm.
they are going to fulfill that duty.
Okay.
Right? And if they don't, they are going to face disciplinary consequences. Do you understand that? So they're going to get you that. You need to pick it up in their office before the close of business tomorrow. If you don't come pick it up by the close of business tomorrow, that will alleviate them from any further responsibility. You understand that?
Can I ask you something? Yes. About the state, I just have a concern. This has been in my mind. The state, why is the state taking this case as though they have full disclosure of this case?
Good heavens, Ms. Butler.
No.
That is certainly not the subject of anything to do with today's hearing.
No, I was just asking because why is the state questioning me like they was there? Because I'm trying to figure out, I'm going against the state versus myself,
Ms.
right?
Butler,
No, I'm asking, why is I'm going against the state versus myself? Why is this not the United States Post Office versus me? Why is it the state versus me?
Ms. Butler, I certainly don't have time to explain.
I need
Oh,
to answer the
that-
question.
No, you don't, because I'm not
Because
here.
in the
I'm not
Constitution,
here to answer you.
Constitution Section 6, it said I have the right to face my accuser. And in the state, it's not my accuser. She's not, or he's not. I need to face my accuser, and the accuser is him.
Ms. Butler, let's get into the motions in limine. I've got
You
a
gotta
motion in limine.
explain that to me, Judge.
I'm not going to, ma'am.
You have to, because it don't make any
You do not have
sense.
to.
So basically, anybody can just go against the state, and the state is considered as a
You're representing
business.
yourself in this
Yes,
matter.
I am, but I need to maybe cross-examine my accuser, and the state is not my accuser. I'm trying to figure out why is the state versus me? Because I do have a right to cross-examine them.
Ma'am,
My accuser got to be a living, breathing individual, not a representative
I
of
need
the
to
state.
redirect you again.
No,
okay?
I
You
just
wanna
want to know
input
why.
that search into Google?
No, I'm wanting to know why.
Or some other search engine of your choice?
Constitutional right, Your Honor.
Ms. Butler, you're talking over me again, and I really don't want to hold you in contempt today.
Yes.
And when you come in for the jury selection, the entire room is going to be filled.
Okay.
And you're going to have to start, the state's going to go first, but you're going to have to stand up after the state's done with their part. And the first words out of your mouth need to be a proper voir dire question. You understand that?
Proper dear question.
Voir dire.
Oh dear, proper
VOIRDIRE.
VO.
And you're going to have to know how to do that.
And I get it, Your Honor. Is there another way besides this?
I'm not sure what you mean.
I want you to draw up because okay, let me say it like this. I don't want to go to trial. I don't, honestly. And the reason why I don't want to go to trial is because I have so much evidence that there's no proof of loss.
Ms. Butler,
I understand. I'm just talking. Just let me get it out.
I just need to stop you, okay? Because I'm not allowed to be part of any negotiating.
I know I'm not going against you, but then
You're not going against me, but it sounds to me like you were roping me into negotiating.
No, I'm not going. No, I'm not.
Ma'am, when you talk about what evidence the state does or doesn't have, that's not something that I'm concerned with. That's something that you need to talk with them about
Oh,
in the process of trying to negotiate something with the state,
I was-
not with me in the room. And I'm not going to permit it. So I don't need for you to talk about what evidence they have or they don't have in front of me.
okay, so I can't talk to them.
I don't know if they'll talk with you or not,
Okay.
but it's also not incumbent upon me to
Okay.
force them to talk to you.
Okay.
They can do what they want.
Learning.
They can refuse to talk to
Learning.
you, or they can offer you some sort of a plea. I'm not going to be involved.
Mhm.
Okay. That's the only other way I know to resolve a case like this,
Okay.
right? Is that you can go to trial or you can do a guilty plea or work out some other resolution. The other possibility is you could waive jury, right? But that's something you're going to want to have some time to think about. It's not something I would accept
But
today.
that
without-
would be the bench trial without.
and then you'd be
jury.
trying it just to me, right? And then I still can't be involved in negotiations,
Yeah.
but then I'd be the sole decider of
Yeah.
the case and the evidence.
Can I also say this? Okay, I know that if you can produce the charges, the amounts, the fees and everything, can you do that as well? Like in the order?
I
Cause,
know what you mean.
I'm trying to figure it out. I know the charges is against my allegiance. I know it says, I'm on the behalf of that. So what I'm
The
trying,
charges are what?
allegiance, you know what that allegiance is?
No.
You never heard of allegiance? Allegiance? It's a creature at law. That's what that is. That's what that is.
Ms. Butler, that has nothing to do with this proceeding
Yes.
whatsoever, and I'm going to stop you, okay?
It is because
What I will do, I'm stopping you. Please don't talk about whatever this is. It has nothing to do with this case or this proceeding.
it's,
What I will do is tell you that if you're going to waive jury, I need to have that decision. I mean, we're right on the cusp of summoning jurors. Do I have another trial set that day?
this is unfair, Your Honor. That's the reason why I don't want to go, because this is an unfair trial.
I still think we'll be okay. I'll give you until, again, a week from today. If you're going to waive jury, you need to make that determination before July 30th.
It's just unfair.
I'm not sure what is unfair to you. What is
Because-
unfair?
Let me tell you why it's unfair.
Yes.
Because I've been drugged.
Oh, man.
You guys got evidence of me being drugged.
Ma'am,
And then y'all using that towards me.
ma'am, no one drugged you.
Yes, yes.
No one's using any
I
sort of-
went to jail. I've
You
been in
go
a
to jail,
mental
ma'am.
institution, and they told me I couldn't leave the mental institution unless I take medication.
Ma'am, there was a
My
procedure.
violation, I've been so violated. Judge, I'm tired. I wanted to dismiss this. All I've been doing is suffering. And then I know I have a right to a speedy trial. I had a public defender. He didn't help me. And now I presented all kind of evidence. He didn't even try to assist me, authenticate or anything like you were telling me in advance. A whole year of my life just been wasted. All kind of violations, like you saying that the United States Post Office or the OIG are victims. Where the court created a victim by drugging me and then use a judge that is actually about to retire to even carry out an order and put it under fraudulent, saying that I'm in a higher level 1 through 5, like I'm a danger to myself and danger to others, and drug me just in order to submit me. The Judge Jeffrey Clymer stated to the prosecutor that this is not a mental case. Do not send her to no mental institution. But you guys did. I am messed up. I'm messed up in the head regarding to how can I, this is an unfair trial. And then I'm up here talking about my statement and they not, oh, we don't know what you're talking about. Oh, we don't know what you're talking about. Yeah, submit it in. It don't even talk about the refunds. It don't talk about theft. It don't talk about nothing. It's just have a lot of statements, unorganized thoughts. And now I want to go ahead and submit. I'll just submit it. That's unfair, Your Honor. I've been through a lot.
Ms. Butler, are you asking me to once again consider whether you're competent to?
This case, Your Honor,
Will deny the
due
motion
to
dismiss.
they do not have evidence of loss. I have proof of that. They did not do their job. It's a one-sided contract, one-sided interview. Because according, I've been working for the post office for 17 years, Your Honor.
Butler, things are going off the rails pretty significantly here. I need to stop you.
A verified complaint, because if you read the probable cause,
Ms. Butler,
there's so much going on in there.
Ms. Butler, you need to stop talking, okay?
It's unfair.
A few minutes ago, you made a suggestion that maybe you're not competent to withstand trial.
It's unfair. I can see the unfairness.
Are you suggesting I should revisit the question of your competence?
Now, witnessing this, that is unfair. When a judge recuses himself, it automatically will be an unfair trial because you didn't ever had it from the beginning.
I need a response to
From the
my
beginning.
question.
You
Are
didn't-
you asking me to reconsider your competency?
It's not reconsider my competency. It's just that I am stressed. And I've been going on for 3 whole years.
So you said you're messed up in the head.
No, I
You
said
think that you need me to reconsider
I'm
competency?
messed up in the head. I'm messed up how the system is so messed up until you try to voice your opinion, trying to conduct good business with the courts. And you try to be reign in honor. That's what I've been doing from the very beginning. Remain in honor. And I'm like, okay, I don't know how to file the documents because this is my first so-called alleged criminal case. And I'm up here trying to cooperate with the judge. But I get drugged. I already went to jail. Already. And then I get a forced plea. Take the plea. I said, I would take the plea if you can show me financial evidence of loss. If you were to look at the document, sir, it doesn't have a financial evidence of loss. But I mean, you gotta have proof. They said, have you ever heard the saying, it doesn't matter how much you know, it's what you can prove in court. And I've been trying to prove what I have here in court, that there's no evidence of loss. That is it. No evidence of theft, no evidence of misconduct. I'm trying to explain this to you.
Ms. Butler, I need to cut you off, okay?
I'm done.